Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is June the 14th of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. For our story today, we turn our attention to the city of Detroit, which for today's story, we turn our attention to the city of Detroit, which has joined other cities in banning cashless establishments. Some businesses don't like cash and they prefer credit. There's a lot of advantages to credit. It has a transactional rate that's trackable, traceable. It allows everything to be audited, prevents stealing of cash, prevents, problems from stealing from the till and all other issues. But of course, not everyone has credit cards, particularly those who are not financially secure might not have credit cards. So this is a problem because some people can't necessarily shop at some businesses, and some cities are doing things about this by making it illegal for those businesses to not accept cash. So let's learn a little bit more about this Detroit law and what's going on. Let's learn more about this. The city council voted to prohibit Detroit businesses from rejecting cash payments through a city ordinance that includes a misdemeanor penalty for establishments that don't accept dollar bills or change. The new ordinance appears to apply to Detroit's largest sport venues, including Little Caesars Arena, Commerce Park, and Ford Field, which all have vendors that only accept credit or electronic payment. Those venues could not be reached immediately for comment. The cashless business ban ordinance was sponsored by a district member. The law requires all city businesses to accept cash for payments of food, drink, good, and services that will go into effect in 90 days. Unclear from the description if this will affect all kinds of services or not. There are some services for which cash may not necessarily be appropriate, but presumably this would apply at least to like corner stores and things that the average consumer might just walk into in sort of a street business, as you might say. So presumably those kinds of businesses, but unclear how far it extends. The person who sponsored it said that she pursued the ban after she had to abandon a salad at a Detroit area building, steps from City Hall because they only accepted credit cards. The ordinance is still accept cash. This will help more than 100,000 unbanked Detroiters. This ordinance is one step in helping the unbanked become fully members of the local economy, and no Detroiter will be left behind. So the city council person does not apparently have a credit card or was unwilling to use one for whatever reason. She's like, cash is good for all debts, and so they should accept cash. So, there you go. More than a dozen public commenters spoke in support of requiring businesses to accept cash for payment. Businesses eliminating cash transactions creates a new line of discrimination based on race and class. Our constitutional rights include the right of any person on the U.S. to use our currency. We need to defend that. I'm not sure it's necessarily a constitutional right. The government of the United States certainly has the right to print money and coinage, but I'm not sure it necessarily flows from that. It's a constitutional right to use that in a private business, but okay. I mean, presumably the United States could pass a law using their authority, but they haven't done that. Under the new ordinance, businesses can have kiosks, but must have the option to accept cash without a minimum purchase amount, which is also true of credit card transactions. Because of credit card fees that come into them, businesses sometimes require a minimum threshold to accept credit cards because they don't want to pay the credit card transaction costs on low transaction amounts. Many occupations still center largely around cash, including those in the service industry and people who get cash tips. Even budding legal marijuana businesses is cash-based because of difficulty with banking, considering that pot is still illegal on the federal level. So yeah, the marijuana business is particularly interesting here because as many states and localities have legalized marijuana, of course, remains illegal on the federal level. And banks are mostly controlled by the federal government, as you would expect. So it is very difficult for marijuana businesses to find banks that will accept their money because they're concerned about being in violation of federal law because it's the instrumentalities relating to criminal offenses. It's the proceeds from crime, and it's knowingly accepting proceeds of crime. And that's a real problem if you're a regulated bank. So a lot of marijuana businesses run in all cash and just have cash on hand or other similar arrangements. It's a weird time out there for the marijuana businesses in relation to all that. In Southwest Detroit, the Coney Island venue remains cash-only restaurant 5 years after in Detroit started accepting credit card payments. There's no federal law requiring private businesses to accept cash, but Detroit joins Philadelphia, New York, New Jersey, and Massachusetts in banning cashless businesses. So this has been something that has been percolating in both major cities and some states requiring the acceptance of cash, which seems fine. Some people can't get credit cards. Some people don't want credit cards. Some people don't want the transactional tracing of credit cards, are paranoid about big bank or whatever, and they should have the right to engage in our society too. Moot's Pizzeria and Bar opened on Liberty Street in downtown Detroit in 2019 as a cashless business, but within 6 months changed its policy following a column by a restaurant critic that pointed out that while cashless business has become a trend that spiked during COVID-19, some customers would be left out. So yes, during COVID, when a lot more businesses were acting arm's length, there was definitely fewer cash transactions. And there are some conveniences in going all credit, some disadvantages, but it does leave some people out. It still makes sense because 95% of our business is credit card, and 5% is more work on our business. Bouncing drawers every night, and sometimes people are not always honest. Cashless was way more efficient, quick, and always accurate. However, it was unpopular, and we have to accommodate our residents. They say the change was made because the eatery didn't want to lose any business and mainly receives cash as people buy pizza by the slice. I do miss the good pizza by the slice establishments. One of the nice things about living in DC, there were plenty of places with pizza by the dollar, or not necessarily a dollar, but sometimes close. And it wasn't necessarily good pizza, but it was a lot of pizza and it was filling on a late night. So I do kind of miss that. I'll just say that it was really easy checking out restaurants at night. We didn't even have a safe, but at the same time, having cash is the right thing to do. I personally didn't like it when I went to Commercial Park recently and didn't have my credit card and couldn't buy anything. Fair. The city's law department said Tuesday they'll be issuing warnings and businesses owners who do not comply. They could face a misdemeanor charge, which would carry a $500 fine. Misdemeanors would be issued to the business itself, not workers. Home-based businesses are not included in the establishment definitions. The city council was concerned about small businesses and adding a waiting period for when enforcement would take place. There's no teeth here, so if we go back to COVID, we need this ordinance to be suspended to accommodate public health. Whitfield Callaway say 90% of Detroit businesses already comply with the issue. I don't foresee it being a problem. Plum Market is willing to be in compliance. There are locations, even at the airport, accept cash. It's just a phenomena in Detroit. Thus, that brings us to the end of this story about Detroit joining a growing list of places that require cash for many kinds of businesses because some people can't get credit cards. Some people don't want credit cards. And so some people are being squeezed out of various things. There's even religious people who have problems with credit cards because some religious people consider it to be the mark of the beast if you're particularly hardcore about such things. So they are looking at this and saying, look, people want cash for all kinds of reasons. There's lots of people who deal in cash, lots of people who get cash, and cash should be a thing. So Detroit has joined other cities in requiring that their businesses also deal in cash. And that, for the moment, brings us to the end of discussion of this story. Good evening, everyone, and welcome to a late night unannounced edition of Legal News Roundup. I'm your host on civil law. Excuse me. We did a deep dive stream this morning. That was nice. And then I did a workout at the gym. Also nice. Kick ass. Posted the results of that question. Then I went to my local meat market, which had a buy one, get one on T-bones, and bought 4 T-bone steaks. Then I ate one of the steaks. It was tasty. And then I was like, let us do late night legal news review, and we will get some stories in the hopper, because since we're doing this whole trial thing, I'm not filming as much content, but I'd like to have at least one edited story every day. So, we have to find time to actually film that, and now would be good. So, we're going to film some stories so that we can add it to the hopper so that I have more stories, because that's good shit. Yes, Jen, this is very live. I did cook the T-bone. I cooked it, then ate it. Yeah. I assumed cooking was implied, but I guess not. Olive oil to coat it, garlic powder, salt, pepper, and then I had a chunky blue cheese dressing that I used for dipping. Numb. Very good. It was numb-tastic. $11.99 a pound, but buy one, get one. So $6 a pound. Fantastic. Bone in. Yeah, the bone in. And the oven arrives tomorrow for even more cooking. Trump's PAC is paying for Walt's lawyers. Well, I'll point out that as a matter of ethics, a lawyer's duty is to the client regardless of who's paying the lawyer. So we'll hope that his lawyers have ethics, I guess. Yeah. Yeah. So yeah. So now I've got a whole bunch of ribeye in my fridge, and now I've got some T-bone. Outstanding. I ate the steak. It was delicious. $7. I mean, equivalent. Because buy one, get one. Yeah. And it was a big ass piece of steak. It was as big as my plate. It was a lot of steak for $7. I was very happy. In the ongoing question of how many genders are there, one schoolyard boy has an opinion in wearing a shirt that says there are only two genders and then being disciplined. Then wearing a shirt that says there are censored genders, still being disciplined. I am imagining the school allows people to wear shirts that express LGBTQ question mark, ampersand, squiggly mark, upside down question mark, caret symbol pride as much as they want, but apparently not with the "are only two genders" shirts. So I'm assuming this is what we call viewpoint discrimination. That is potentially per se unconstitutional. The flag burning case suggests as much with Texas v. Johnson, with the flag burning case. Might be able to restrict the topic, that's subject matter. But if you allow the subject, but only some perspectives on the subject, viewpoint discrimination. So we're in a whole new world of unconstitutional. But the school's doing it anyway. Let's learn more about this story. In Massachusetts, the Middleborough seventh grader is asking a Boston court to halt his school ban on t-shirts that say there are only two genders, to which he was forced to go home, sent home for the day because he wouldn't take off his shirt, and then wore a shirt saying there were only censored genders, which the school then also ordered him to remove that shirt, violating his First Amendment rights, a lawyer has said. Yeah, I think so. I'm going to go out on the presumption that they allow the LGBT question mark, ampersand, backwards squiggly marks shirts. So not allowing this is a pretty big First Amendment issue, I think. Liam over here wore a t-shirt saying there are only two genders to Nicholas Middle School in March, and the principal of the school, along with the counselor, pulled him out of class and ordered him to remove the shirt, according to the boy's attorney. After he politely declined, school officials said he must remove the shirt or he cannot return to class. As a result, he left school and missed the rest of the day, said his lawyer, who will argue the case. After that, he wore another school shirt that said there are censored genders to protest school officials that only some messages about genders are allowed. As soon as he arrived in school, his teacher instructed him to go to the principal's office, where he's told he couldn't wear that shirt either. So I'm not even allowed to note that. I guess we'll have to go back to wearing the black armbands. Maybe he can wear the black armband and protest and just pull a full tinker, go 180 degrees. The legal counsel that's assisting him is working for the Alliance Defending Freedom, which, along with Massachusetts Freedom Family Institute, filed a lawsuit on behalf of Liam. This isn't about a t-shirt. It's about a public school telling a seventh grader he isn't allowed to hold a view that differs from the school view. Yeah. Viewpoint-based discrimination. Viewpoint-based discrimination. That's a real... Public school officials can't force him to remove a shirt that states his position when the school allows every other student wearing clothing that speaks on the same issue. If they didn't allow anyone to wear shirts on the issue, then we'd only be in subject matter discrimination. But they allow some people to express some views and not others on the same subject, viewpoint discrimination. Their choice to double down and silence him when he tried to protest is gross violation that we're urging the court to rectify. The news reached out to the schools for comment. An assistant superintendent declined to comment, saying the school district is represented by legal counsel and this is a matter of ongoing litigation. Yeah, if the courts don't have their head completely up their ass, the student is going to win. So we'll see how it goes. There was a hearing for a motion for a preliminary injunction, which actually was granted, that requested the court to prevent the student from wearing the school while the case proceeds. So the court actually granted the injunction. I imagine we're off to appeal already, because injunctions can be appealed immediately for that interlocutory appeal, because they granted the injunction in favor of the school. So how? Given Tinker, given BL versus Mahoney, how? Were there actual disruptions in the school? What are you doing? The Alliance Defending Freedom is a nonprofit legal organization committed to protecting religious freedom, free speech, parental rights, and the sanctity of life. In the case, Alliance Defending Freedom attorneys argue school officials have adopted a particular view on the subject that a person who identifies determines whether they're male or female, not a person's sex. They've expressed this view through their own speech, institute school-wide events celebrating the view, and encourage students to engage in their own speech on the subject as long as it's the school's favored viewpoint. School officials admit their policies permit students to express viewpoints supporting the official's view of gender, but forbids it from expressing. Dude, man, that should be easy. I mean, that should be really easy. That's about as unconstitutional as it gets. It's pretty hard, right? You are allowing the subject to be discussed. So you're not even saying no discussion on the subject at all, in which case subject matter discrimination. You're specifically saying, yes, we'll allow discussion on the subject, but only certain views. This should be really easy. And the district court granted a preliminary injunction in favor of the school? Does the district court understand the case law? I'm not sure the district court understands the case law. It is a district court in Massachusetts, but still. Liam wore the shirt to peacefully share his belief, informed by scientific understanding of biology. Now, you can't have that anymore, not in schools. Biology and science? No. You trust the science except when it's inconvenient. That there are only two sexes, male and female, and the person's gender is inexorably tied to sex. At this point, I'm not even sure the term gender is helpful. I'm not even sure the term gender should be used at all. It seems to be just a description of personality traits. So I think calling it personality traits might be better. I'm not sure the term gender really is a useful term at all, but that's maybe just me. The boys' attorney says the case involves the school's censorship of message, along with their decision to silence speech protesting censorship, which violates the Constitution. It sure does, but it hasn't been going well for the student thus far. Thus, that brings us to the story about a schoolboy, seventh grader, fighting the fight for the right to say that there are only two genders. and that, biology is the determiner, which, is his view. And he should be allowed to express that view. The school apparently has no problem with the contra view, but has problems with his view. And there doesn't seem to be any indication of actual disruption in the school. It's all prophylactic, which doesn't conform to Tinker or BL, and also doesn't conform with Texas v. Johnson when it comes to viewpoint-based discrimination, among a litany of other cases speaking about this issue. So I don't know why the district court granted in favor of the school. Perhaps they are unaware of such cases. That's okay. Tinker's only been in the law of the land since the 1960s. Maybe the district court hasn't gone that far in their law books yet. Oh well. But this case will proceed presumably with an immediate appeal to the First Circuit on the injunction. And that, for the moment, brings us to the end of discussion of this story. I like steak. Push the button. I like steak. Steak is good. I like steak. Push the button. I like steak. Moo cow in my stomach is good moo cow. Moo cow in my stomach, it is tasty and good for me. Moo cow in my stomach, good for post-workout recovery. Moo cow in my stomach, moo cow is good for me. Moo cow in my stomach, it is good for post-workout recovery. And yes, it is still racism when you discriminate against white people and also F around and find out news. Starbucks has been fined $25 million for firing a person because they're white. You can't do that. You can't fire someone because of their race. It is, in fact, racism when you fire someone because of their skin color. Yes, even the whites. And Starbucks has to pay $25 million now. So, that's a lot of lattes. Let's learn more. Five years ago, Starbucks came under scrutiny after an employee at one of its city center coffee shops called the police on two black men who were sitting in the store without buying anything. This was a major story at the time. This went viral at the time. Starbucks got a lot of grief, right? These two black men come in, don't buy anything. Is like, why are you here? And then call the police. And it was a huge brouhaha. In the aftermath of the situation, Starbucks filed the regional director who oversaw the location, prompting unlawful termination lawsuit from the woman who claimed she was let go because she was white. Okay, yeah, so the regional director, who presumably isn't at the store at the time, is fired in this incident. And she's like, you fired me because I'm white. Well, the jury agreed. Starbucks has been ordered to pay $25.6 million after a federal jury in New Jersey found the company violated the employee's civil rights in a New Jersey law prohibiting discrimination based on race. They awarded $600,000 in compensation and $25 million in punitive. Well, bad news, by the way, that amount will be reduced massively. There is a case called State Farm in the U.S. Supreme Court, which says that, you shouldn't have more than 10-time multiplier. And even says more aggressively than that, really. It says more than 3 is probably bad. So I'm not sure about exactly what the relevant law is in this particular case, but this amount will be reduced. So they got $600,000 in compensation. So the $25 million in punitive will be reduced, presumably, to $6 million or less. So, but still, they're getting paid a lot of money. So so yeah, it's not a bad payday. It's probably not a $25 million payday, but it's a nice top line number. The employee in question was a 13-year employee of Starbucks at the time of the incident. The incident drew national media attention. She oversaw Starbucks operations in Philadelphia, South Jersey, Delaware, and parts of Maryland. So she's pretty high up in the company, right? She has a nice little territory of stores. In the aftermath, the lawsuit alleges that she worked tirelessly on Starbucks' behalf to repair community relations while ensuring employee and customer safety. She claimed that Starbucks sought to punish white employees in the Philly region, even those who had been involved in the incident following the media coverage of the arrests. So yeah, we just went on a firing spree of firing the whites, even people who aren't involved, because we want to look good. As part of damage control, Phillips claimed that one of her supervisors, a black woman, told her to place a white employee who oversaw the Philadelphia stores on administrative leave because of allegations of discriminatory conduct. Phillips said the accusations weren't true and that she was ignored when she presented information to clear the employee's name. Phillips also said the Starbucks did not take steps to punish a black district manager who was responsible for the Philadelphia store where the arrest actually occurred. So she's a regional manager. Below her is a district manager. And below that, presumably, is the store manager. So she's higher up in the organization, right? So the black district manager, who oversees a group of stores, wasn't punished, but the white regional manager, who oversees many more groups of stores, is punished. So that seems odd. Phillips also claimed Starbucks did not take steps to punish the employee. Phillips was fired less than 1 month after the incident. They fired suit in 2019, but the trial only began last week. On Monday, the jury deliberated for 6 hours before reaching its verdict. The lawyers said that they and their client were very pleased. I bet they are. Starbucks, however, has denied the claims, saying, quote, all actions taken by Starbucks with respect to Phillips were legitimate, non-discriminatory, non-retaliatory reasons, the company said. Any damages suffered were approximately caused by our own conduct and not any unlawful policy, custom, conduct, practice, or procedure. The jury doesn't seem to see it that way, Starbucks. If only we knew for sure why she was fired. If only we knew for sure why she was fired. Sounds like a question of fact to me. Whoever could we ask? On April the 12th, the 23-year-old man went to Starbucks for a Thursday afternoon meeting with a business partner. The entrepreneurs arrived early. One of them asked to use the restroom, but was told he could not because he was not a paying customer. After he sat back down with his friend, the store manager asked where the men wanted to order anything. They declined, saying they were waiting for someone. At 4:37, 2 minutes after the men arrived in the store, the employee called the police, officers arriving 4 minutes after that, which is one hell of a response time, by the way. You can't get the police to respond this fast for shots fired. Damn. I was thinking they can't be here for us, this person said. We have meetings in Starbucks all the time. Police told them they have to leave if they weren't going to buy anything. They were eventually arrested and they held the man in police custody for 9 hours before releasing them. After a video went viral online, Starbucks was met with protests and widespread public outcry, with people calling the incident of racial profiling. The CEO at the time had to issue an apology and traveled to Philadelphia for a struggle session with the mayor and the former Philadelphia police commissioner. The men who were discriminated against reached a settlement with Philadelphia. They each received $1 in addition to a pledge for $200,000 from the city to create a youth entrepreneur program. Starbucks also closed 8,000 stores for a day to pull its employee through racial bias training. So the men who were discriminated against got $200,000 for a charity. She got $25 million for the racism. So didn't work out too bad for her. So I look forward to someone saying how it's racist the white person got so much more than the black person anytime now. Thus, that brings us to the end of this story about Starbucks manager getting paid. $25 million by the jury, but that will be reduced to some lesser amount. So they'll probably only walk out with something like $2 million. How sad. However, will they cope? That's a lot of lattes. Unclear if it also includes free coffees in the future. But yeah, so Starbucks is going to have to write a check. We'll fight over how big a check at some later time. And that, for the moment, brings us to the end of discussion of this story. Push the button. Yeah. Let's see what else we got. What else do we have today to discuss? Da, 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 da. Okay, this one's kind of local, but I'm covering it anyway because I can. It's my channel. You can't stop me. Ha 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 ha. I can cover whatever I want. Yeah. Has 25 million turned into 2 million? Well, as I discussed, there's this case called State Farm from the US Supreme Court, which says that punitive damages can't be more than 9x and also strongly implies they really shouldn't be more than 3x. So since the underlying damages for compensation were $200,000, 3x of $600,000 would be $2 million. So I rounded. So 2.6. That's how. State Farm. Like a good neighbor, State Farm is there. All right. In Texas news, Texas has passed a law to deal with a fairly serious problem in the Lone Star State. There are a lot of people riding around, disturbing amounts of people, as it turns out, who have invalid, faked, forged paper license plates. So when you buy a new car, sometimes they give you a paper plate. It's perfectly legal. The problem is people were printing them off on their home computer because it's not exactly rocket science, and they were just forging them. And then they tried to solve the problem by putting a QR code, but then people faked the QR code. The QR code didn't go anywhere, but it looked right at glance. So there are a lot of people driving around with these phantom plates. So Texas, finally getting around to dealing with this problem, says no more. We're not doing this anymore. Not so much, because we're tired of this problem. So we're ending the paper plates. Thank God. Let's learn more. A new era of ubiquitous metal tags is coming to Texas following the passage of a Texas bill, which will end the use of paper license plates in the state. Thank God, not too soon. The governor signed a bill into law on Monday. The new measure requires dealers to issue $10 metal plates to buyers purchasing cars and nix languages in existing licensing laws, referring to the use of temporary buyer tags. So yeah, just get a metal plate like a normal person, and just give them the metal plate when they buy the car. Congratulations, you give them the metal plate. We'll give you some, and then you can give up the metal plates, and they'll be registered to the car. It'll be great. Introduced by a representative from Fort Worth, the bill in question received bipartisan support, earning co-sponsorship from 12 lawmakers, including Dallas Democrats and Houston area Republicans, because everyone's kind of tired of this shit. Paper tags have become the bane of the state and nationwide enforcement in recent years. Many officers contending that temporary plates are easy to fake and found on cars used to commit crimes. Yep, they're a little bit problematic. People making the paper plates, printing them off on their home computer, not exactly rocket science. They just print them off and, on their home printer, because how could you possibly tell the difference? So it's like, let's not do this anymore. A 2021 investigation found that fraudulent Texas dealers were able to register with the Department of Motor Vehicle and use their access to generate thousands of fraudulent plates. Also, people were just doing it at home. I mean, yes, some dealers were also in on the scam, but also people were just literally doing it themselves because it wasn't that hard. A report by a news outlet found that the selling of these fake plates by dealerships had ballooned into a $200 million illicit business in which people in Texas were able to distribute cars with fake information to 50 states, a problem causing rampant headaches for law enforcement because, they're issued by Texas, right? So they're valid plates. So people are driving around with these Texas plates all over the place. So causing a bit of a headache for our entire nation. Kind of pissing everyone off. Texas, as you might notice, is somewhat of a huge state. So it's kind of easy to blend in because it's the second most populous state in the country. A lot of Texas plates out there. A lot of fake Texas plates. What if we didn't have fake plates anymore? That's a good idea. The investigation led to the DMV to vote in favor of fingerprinting all car dealers in the state upon renewal of their driver's licenses. Maybe we should check to make sure that the car dealers aren't, felons. That sounds like a good idea. Maybe we should do a background check. to see who's selling cars, because it turns out some of them were involved in a $200 million conspiracy that stretched the nationwide. Fun. A 2020 report reviewed by Harris County estimated that at least 1.8 million cars in Texas are without real plates. And the fraudulent paper tags that cost the county $80 million in registration fees, plus the cars aren't registered, plus probably not insured, plus, not inspected, plus everything else. Yeah. So maybe 2 million cars in Texas and God knows how many nationwide. And Texas is like, what if we stopped being stupid about this and issued metal plates? Wow. Neat. A sergeant for Travis County told the news that signing the bill is a mammoth step. This is going to help everyone across the United States. One would imagine. Yeah, because if you see a paper plate, right, it's not from Texas. And, if it's from a different state, there's not as many of them. So, yeah. That's going to help everyone across the United States. This is huge. I'm very, very happy. Is it going to end tomorrow? No. We'll have to wait and we'll have to be patient and keep on fighting the fight because we have another year and a half or two to wait. The Texas DMV is until December the 1st of 2024 to come up with a plan for expediting the creation and supply of the tags, which will go into effect July 1st, 2025. So it doesn't go into effect for 2 more years. But damn it, we're trying. Okay? So in 2 years, we're going to fix the problem. I'm not sure why it takes 2 years, but I guess we have to print more tags. I guess. I don't know. But apparently we need time. All right, fine. Thus, that brings us... Okay. Thus, that brings us to the end of this story about a Texas phenomenon that was causing all kinds of headaches for everyone everywhere. Texas had paper tags. They were perfectly legal. And, they were convenient because, hey, paper tags, this is only good for 30 days. Go get your metal tag. Oh, sure I will, boss. And then dealers were like printing them off en masse. And then some people were just printing them off at home because, it's a paper tag. You can print it on your printer because it's a paper tag. A little bit of X-Acto knife or something, not very hard. And Texas is like, what if we stopped being idiots? So 2 years from now, we're going to have metal tags. So that's nice. So looking forward to that change. And maybe we'll get some of these cars registered and some of these ghost cars off the road, and we won't have people uninsured driving as much. That'll be nice. And that for the moment brings us to the end of discussion of this story. There's only 5 likes on this video? Oh, okay. I was like, damn, what do I have to do to get some likes? Shit. Push the button. Yeah. Hey, 20 gift memberships. Thank you. It's a dumb name, so I changed it. That's nice. Yeah. I like steak in my stomach. Steak in my stomach is good for me. I like steak. Steak in my stomach. Steak is good for post-workout recovery. Getting gains, eating steak, pushing weights, eating steak, pulling cables, eating steak. Steak, 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 steak. Num, num, num. In my stomach, num, num, num. It's good for me. Is Wednesday night casual evening? It is now. Dab? Oof. Oof. You thought it was a legit commercial jingle? Outstanding. All right. I love you, chat. I'm in a great mood today. I'm in a great mood. It's good steak too. It's good quality steak. If my guy can get me steak for half off regularly, I'm going to go back to him all the time. He says it's halal. I believe him. It's good and tasty. We're planning to be on tomorrow, by the way, for the trial. I think it's scheduled for like 8:15 or something. So I'll post the link for tomorrow. So it'll be good. All right. And I wasn't aware that only courts can issue court orders news. An attorney has been sentenced to 2 years for faking court orders. You know, I really would like those court orders. They would really help me and my clients, but sometimes getting the court orders can be a little bit tricky. What if I just made them up myself and signed them myself? Presto bingo, it's a court order now. It has a signature on it and everything. What could possibly go wrong? Let's learn more. Last year, attorney Andrew Gavin Wine found himself on the wrong end of an indictment for 5 counts of identity theft for faking documents up to and including court orders and judgments. Wow. He's just issuing final dispositions in his case. He's not even like issuing like, you know, discovery orders or something. He's not even issuing, you know, sort of, you know, management orders. He's issuing full-on judgments. Wow. He pled guilty earlier this month and received a prison of 31 months, and has to pay $350,000 in restitution for the fraud. The Missouri attorney worked for the firm of Manise and Wine, now known as Manise and Manise. They took out the wine name out of their partnership for some reason, not clear. Apparently filing multiple fake orders throughout various matters. As the ABA has noted, in one case, Wine allegedly filed a final divorce order requiring a husband to pay $900 in child support, according to an ethics filing. Wow. That's all kinds of special. Wow. I'm issuing divorce orders. I'm issuing child support orders. Holy shit, dude. Does Rob do this? Hey, Rob, I know you watch the channel. Do you have any thoughts about an attorney in the child custody matters just issuing their own court orders and issuing their own child support things? Is that the kind of thing that you and your friends get up to? Is that how we roll? I don't know much about child support law. Is that normal? Lol. In another case, he allegedly created an order of contempt requiring a husband to pay $20,000 within 15 days and then half his income plus $2,500 every month. Well, geez, that is really nice. I mean, you know, I bet Rob has never thought of this one simple trick. Rob actually has to go to court and argue for his clients and try to get them a result. Rob has never thought of the one simple trick that will let his clients win every time. What if I just issue the orders myself and say, yes, you will give me child support. You will give me half your income plus $2,500 every month. Well, golly gee whiz, guys, that sounds special. Whole new practice area over there, I'm supposing. This is good shit. It is shocking an attorney can get away with this, apparently. Dockets are increasingly electronic and searchable. Even pro se litigants can check to verify orders. Did no one ever seem to challenge these rulings? Apparently not. Apparently, the opposing attorneys and the opposing clients just took them at face value. I mean, they didn't even bother to go look it up in the court system to see if it was a real order. Because why would you, to be quite honest? Why would you go look? I mean, seriously, why would you go look? The idea that the other attorney is forging court orders is so far afield. It's like, no, I didn't think to check to see if it was a real order. Holy shit. What do you mean it was fake? Godly damn. Every allegation in the case tracks a stunt that would barely fly in the 80s, much less 2020s. And the most absurd part is this isn't even the worst case of forging George signatures. Wow. Maybe this is a good reason to be skeptical of court orders if you're on firm salaries. Good times. Fun times had by all. Thus, that brings us to the end of this family law attorney, one of Rob's colleagues out there in the great wide world, who apparently decided that, being a family attorney is a little bit rough sometimes. And you know what would make it easier? What if I just issued child support payment orders myself? What if I said, give me half the money plus $2,500 every month? Well, golly gee whiz, guys, it's just that easy. I write them up myself, sign a little sign, no problem. Wow, the checks start coming in. What a miracle. Finally, someone figured out that this wasn't real. And they had a little chat about it. Probably not going well for his attorney law license, I would expect either. And also getting 2 years in court orders. So that's going in court in prison time. So not going great. And that, for the end of the moment, brings us to the end discussion of this story. Push the button. Yeah. Push the button. Yeah, Rob over here with law and lumber. Hey, Rob, how would you like to have less law in your life and more lumber? Here's one simple trick. If you do this, there will be a lot less law and a lot more lumber, I guarantee. All right, let's see what else we got. All right. I see I was unable to summon Rob to the chat. I was kind of hoping that he would be summoned through my sheer power of suggestion. But alas, no. All right, let's do something else. In culture war news, the state of Texas has passed a law that requires its state colleges to get rid of diversity offices and its campuses. So yeah, this has obviously been an issue, and Texas isn't so thrilled with the diversity, equity, and inclusion in its state, and said, you know what if our state colleges don't have those offices? Because we think it's really, really dumb. We don't really like it. So kind of going the Florida route over here. Of course, because they are the state's colleges, the state obviously has a lot more control over what kind of offices, and even to some degree, what is taught at those colleges. You get into issues with tenure and some other stuff. It gets a little bit complicated in the college domain, as opposed to high school, where the state has even more control. So like when Governor DeSantis was passing some of the stuff through K through 12, Florida had more control, and here it get a little bit more nebulous because they're colleges. But in any case, this shouldn't be a problem because this only speaks to an office rather than the teaching. So it shouldn't be a problem. And they ban it as a matter of state law. So let's learn a little bit more about this. Governor Abbott has signed a bill aimed at dismantling diversity, equity, and inclusion offices and programs in colleges after months of debate. With this bold, forward-thinking legislation to eliminate the program, Texas is leading the nation in ensuring our campuses return to focusing on strength of diversity and promoting a merit-based approach where individuals are judged on qualifications, skills, and contributions. Wow. Yeah. I mean, how about based on merits? Whoa. Maybe it should be based on merit. That sounds good. Yeah, let's do that. What sets the bill apart from other proposals is that the legislation delivers strong enforcement with mandates to return Texas colleges and universities to the core mission of education and innovating. Is that the entire story? Okay, no, I was about to say, I need more. The bill, of course, was challenged by Democrats every step of the way because they super love the diversity, equity, and inclusion. But starting January 2024, so basically in the spring semester, Texas campuses must eliminate the diversity, equity, and inclusion offices, the mandatory statements, and any related training. In addition to closing down the offices, the new law prohibits colleges from requiring diversity statements from job applicants and conducting mandatory training relating to this. So no more struggle sessions in work training. So that's positive news. Utah Austin's president of the campus is one of few college leaders to make a public statement about the bill. He asked for community's patience while his team works to understand the contours of the new legal framework and how the UT system will implement oversight. What will not change is our university's leadership commitment to attracting, supporting, retaining exceptionally talented staff, faculty, and students with diverse backgrounds and perspectives, and fostering and celebrating diversity across our community. UT Austin president of the campus not having a great time over here. He's not super thrilled that the state is like mandating how he has to run his campus, but it is a state school. So, you know, it belongs to the state. So, buckle up, buckaroo. And if you don't want the job, I'll take it. You can elect me college president. I'll do a great job. Abbott also signed a bill that codifies tenure into state law and makes it easier for universities to revoke the designation from faculty. So the entire idea of tenure, where a person essentially can't be fired for cause, is an issue of state law, and this had been a little bit more informal or a little bit on the common law. So now we signed a bill that codifies the concept and also makes it easier to revoke it, so we don't get stuck with bad faculty forever. Republican lawmakers had tried to eliminate the designation in Texas altogether, but apparently unable to get that far. Tenure, which is awarded based on merit, guarantees professors academic freedom. The process to obtain it usually takes 6 years, during which faculty obtains performance reviews. Tenure professor, okay. Currently, tenure professors indicate Currently, tenure policies indicate professors can only be terminated for justifiable cause or under extreme circumstances, such as a program's discontinuation or severe financial restraint. Many professors had said such protections are essential as they teach and conduct research. Under the new law, universities will now be able to dismiss professors for exhibiting professional incompetence or moral turpitude, neglecting duties or professional responsibilities, failing to complete post-tenure review, violating law or policies of a university or institution, being convicted of a crime, or engaging in unprofessional conduct. Well, that sounds pretty good to me, that we should do those things. Those sounds like bad reasons for people to continue to be teachers. Let me redo the line because the tone won't work properly. Well, those all sound like good things to me. Those sound like good reasons to no longer have people be teachers if they're breaking the law or engaging in moral turpitude or otherwise being incompetent. So, seems like the Texas legislature is really trying to make sure that teachers, actually competent. Thus, that brings us to the end of the story of Texas joining Florida in fighting the good fight in the culture war. And I am thrilled because I am tired of all this shit. I am glad that Texas is fighting this fight as well they should, and making sure that, schools do school things like teaching education and not so much with the indoctrination and the cultural Marxism and the bullshit. So all that good stuff. So that is going into effect this January. No more DEI offices, no more mandatory training, no more bullshit. So I guess now the people who really love it will have to have their secret society and poetry readings in a cave or something. I don't know. And that for the moment brings us to the end of discussion of this story. Push the button. Yeah. Button time. Button time. Button time is good time for you and me. Steak time. Steak is good food. Steak comes from moo cow. Cow go moo. Cow in stomach. Cow is nutritious for uncivil. Cow time. Cow time. Let's see what else we got today. Okay. I could discuss the indictment of the guy on the subway choking, but I'm not sure I want to discuss that right now. Twitter facing a copyright lawsuit. I don't know if I want to discuss that right now. Let's discuss another lawyer behaving badly. Kind of worried. Kurt seems to be happy. I don't know how to interpret that. Lol. I'll take it as a tease, I guess. We got so used to depressed Kurt, we're not sure what to do with happy Kurt. All right. In client money is not lawyer's money news, a lawyer has learned client money is not lawyer's money after gambling millions of dollars of it away. Yeah, okay, look, messing with the client's money is pretty much the easiest way for a lawyer to get fired. Don't F with the client, don't F the client's money, don't F the client themselves. Yeah, so the millions of dollars of gambling losses with the client money not ending well. Let's learn a little bit more about this story. Accused of blowing somewhere over $8 million in client funds. Holy shit, dude. That's a little bit of a gambling problem. $8 million of client money? Holy shit. Dude, self-control problems. After moving into the Wynn casino, they moved into the casino. That's how bad the gambling is. And gambling 24/7, the attorney, Sarah Jacqueline King, will reportedly plead guilty to wire fraud and money laundering, facing up to 20 years, and needs to pay $8.7 million to recoup 5 people. Holy shit. Yeah, so please don't steal the client money. Please don't steal $8 million of the client money. Please don't move into the casino with the client money. Please don't put the $8 million of the casino money on black. Yeah. At one point, the business was rumored to have transferred millions of investments into a mere $12. Oopsies. Apparently, she's found some more if she's taking on restitution obligations. The matter began when a Virgin Islands entity called LDR sued King. Plaintiff is informed to believe that King moved into the Wynn Las Vegas resort and hotel, lived there for 6 months, holy shit, and gambled 24/7. Wow, that's a lot of gambling problem. You move into the casino and all you do is gamble all the time. Holy shit. LDR alleged that King owed them $10 million. Other suits allege similar, if smaller debts, one alleging she failed to repay $125,000 loan, another claiming she pocketed $62,000 loan. She apparently is not a fan of the penny slots. I guess that's one way to put it. The feds, apparently taking note of all this, then got into the party. King will make an initial appearance later this week and is expected to plead guilty to the $8 million of client theft. Wow. Thus, that brings us to the end of the story, which apparently, you can't take the client's money. I have heart attacks about misplacing a decimal point, when it comes to the client money. This person's over here with the $8 million in fraud. Holy shit. That's a lot of fraud. She moved into the casino for 6 months and was gambling, and now is going to plead guilty to the wire fraud and owes $8 million in restitution, wherever that money's going to come from. I don't know whether or not she's doing dice games in the prison yard or not. We'll see. And that, for the moment, brings us to the end of discussion of this story. Holy shit. Press the button. Holy shit. You don't think the Wynn is a nice hotel? What's your pick? What's your pick for a nice hotel in Vegas? What do you think is you want to do like the Caesars maybe? Or yeah. It's because of people like her that I have to pay like $50 a year for the client restitution fund. The Marriott? Circus is not that good. Shooting was at the Wynn. No, the shooting was at Mandalore Bay. Yeah, shooting was at Mandalore Bay. I remember. Area? Okay. Bellagio? Bellagio's a solid call. All right, let's see what else we got. I don't want to talk about anything else. Let's do Florida Man and wrap it up. I want a soda. I want a cocktail. I think. Let's see what's going on. Let's see if we can find a Florida Man case to discuss. Let's see what is going on today. Florida Man, Florida Man. What is going on in your world? Let's see. Let's see. I'm not seeing anything really interesting right now in Florida Man world. Let's take a look at this one. That's just lame. No Florida Man today. All right, so what else should we talk about? I think we got like a couple stories out of that. We'll film a little bit more on the weekend, but that was good for now. Waldorf? No, Waldorf I would imagine is nice. I don't know where the Waldorf is in Vegas. Is there 4 Seasons in Vegas? I imagine that's nice. Did my crock pot, you mean my toaster oven? Tomorrow comes in. I'm pretty excited about that. What's my latest awesome find? Well, I just found a new place to pick up meat today. So that was nice. I covered the South Carolina Supreme Court redistricting decision. As a matter of fact, we did a deep dive on it this morning. We went through the decision in full this morning on the Supreme Court redistricting decision. So yes, you can watch that, and it was an interesting case. Oh, thank you, Silk Starlike. I respond to live comments as I can. I obviously tend not to respond to them in the middle of stories because it completely breaks up my flow. Because I'm doing one thing and then it's like I can't really switch to the chat and then switch back. So I tend to do it in between breaks. Unless, of course, it's like a super chat, then I try to do it with it and it doesn't break up my flow. But it's a little challenging sometimes. But I try to engage with the chat. I think I do a pretty good job of engaging with the chat. Do I like protein shakes? Sometimes. I like them in the morning sometimes. I'll make like an 18-ounce thing of coffee, throw in some protein powder in there, some amazing greens, sometimes a little throw in a little butter for a little fat. Shake that up. It's a good morning breakfast thing. So it also makes the edit easier if I don't talk in the middle of the story. That's true. It also makes the edit a little easier. So all right. I think I'm gonna sign off and have some Coca-Cola and whiskey of some version. Or maybe I'll just have a beer. Maybe I'll just have a beer and play some Zelda. That sounds fun. Probably play it offline though. But yeah. So we'll be on tomorrow morning, probably 8:15 Central, 9:15 Eastern, for the trial. And then I have this, and I also have the stuff from last Monday and Tuesday, which I still haven't edited. So I have that I can edit, but I still have stuff in reserve too. So I need to edit stuff. But yeah. Buffalo Trace is a solid choice of whiskey. Any comedy shows in my area? Sure. I live downtown Austin. There's a damn comedy mothership now. I'm gonna sign off for now. Hey, how you been there? How you doing? I'm gonna sign off for now. I'll talk to you later. Bye.